Hello everybody, welcome. Today we're going to talk about a case where the I-130 and especially the I-485 has been pending for a while. I am exercising my free speech rights as an American to look at the court records to see what is happening with immigration. So here we have a case that is filed at the U.S. District Court for the District of Maryland. So usually the I-130 and I-485 are usually filed in the District of Columbia, but since it looks like the plaintiffs reside in Maryland, I guess their attorney decided to file it in the District of Maryland. But usually it is filed in the District of Columbia since that's where the defendants reside. So we have two plaintiffs. And then we have these defendants. As usual, they listed quite a bit of defendants and relatives. So we have plaintiff. So they refer to as plaintiff A and then plaintiff B. So it's two plaintiffs. I mean, usually when most people tend to write the complaint, they don't usually write as plaintiff A, plaintiff B, but we figured out which one is which. So here it says in the introduction, the plaintiff's application to adjust the status to a lawful permanent sentence in the I-485 and the petition for alien relative, there has been some delay. And plaintiff B, so plaintiff B is the U.S. citizen that is filing the I-130 petition for alien relative. They filed it at the beginning of 2024 and then concurrently filed the I-485, the adjustment of status, since the beneficiary is in the U.S. with the USCIS. And then they're saying that it's improperly held and the application has been pending for an unreasonable period of time. And they're saying regarding the jurisdiction and venue that this is a federal question. It's a mandamus to compel an officer to perform their duty and compel an officer and employee of the United state to act because it is an Administrative Procedures Act. And then they're saying that if the agency fails to render a decision within a reasonable period of time, the court has a power to compel the agency to do so. So that's what they're filing it in court. Here, the venue is proper because it's a district court for the District of Maryland. As we have seen, most of these I-130, I-485 are filed in the district for the District of Columbia because that's where the defendants reside. But they're saying because the action against officers and agencies in the U.S. in their official capacity is brought in this district. Why? Because the plaintiff resides there. But you don't have, usually even if the plaintiff resides in certain state, because the defendants reside in District of Columbia, most of the time it is filed in District of Columbia. And so they're saying, therefore, the court has jurisdiction because it's in Maryland. And then the parties is the plaintiff is eligible for adjustment of status due to his lawful entry into the U.S. and marriage to a U.S. citizen. And then the plaintiff applied for adjustment of status and has been waiting for a decision on the application since that date. The plaintiff B is the resident of Maryland. And then here's all the defendants they're going to list. So they're saying defendant is sued in the official capacity as the Baltimore District Director of the USCIS, and another defendant sued in the official capacity as the Acting Director of USCIS, and the defendant is sued in the official capacity as the Secretary of the Department of Homeland Security. In terms of the legal background, they're saying that this law allows immediate relatives to file for the alien family members and then to have them adjust their status. And then here they're saying if USCIS fails to make a determination within a reasonable amount of time after the application has been filed, the applicant is entitled to an action on this long pending adjustment of status, and the court has power to compel USCIS to take action. The court has power to compel USCIS to take action, but you don't know which way. The court cannot compel USCIS to take a different action if they were to deny certain application. I mean, we have seen that as well, right? So just a quick fact on this is a plaintiff A is a native and a citizen of Zambia. Okay, well, that seems to be an issue. So if for men that are from Africa, like Ghana, Nigeria, Zambia, and other countries in Africa, things tend to get slowed down. I mean, we have seen that in prior filings as well. USCIS seems to give a hard time to men or people from Ghana, Nigeria, Zambia, and those types of countries. Plaintiff A was admitted to the U.S. On an F1 non-immigrant visa. So F1 is a student visa. So they came on a non-immigrant student visa. Okay, so usually, F1 goes to OPT and then H1B. But anyway, but I guess he met somebody, and then he has never left the U.S. and married the U.S. citizen. And then plaintiff B is the U.S. citizen, filed the alien relative for I-130, and then concurrently filed the I-485. And then here's where the issue starts. I guess they attended an interview, and then they asked for additional specific evidence. They don't tell you what evidence they requested, but I guess they provided that evidence shortly after the interview. So they had one interview, and then they were called back for the post interview. That's never a good sign. They were called back for a post interview, and then they were told to wait until March 2025, and that date has passed. So there is historical data on the USCIS website. You can see how long certain applications are taking. So they're saying that USCIS historical national median processing time for USCIS was about 11 months in 2022, 13 months in 2023. I'm sure the time is much longer now. And it's been over a year since the plaintiff filed their application. And then they're saying the defendants unreasonably delayed and refused to adjudicate. And they're saying the plaintiff the defendants owe a duty to the plaintiff to adjudicate the application. They waited over a year. Okay. And some of the damages, they're claiming that because he's an I-485, he's not protected. He could be placed in a remote proceedings. He cannot travel. He has to keep renewing his work permit. He cannot sponsor his family until his I-485 permanent resident has been approved. And then they're saying that, he can be eligible to become a U.S. Well, here's what it is. Any delay in the plaintiff permanent residence also delay in his potential naturalization, which he could be eligible for 3 years after permanent residence as he's married to a U.S. citizen. Basically, they're saying that, if you're married to a U.S. citizen, you can apply for U.S. citizenship in 3 years. If not, it's traditionally 5. So that it's saying that it impedes the plaintiff's right to vote, travel outside the U.S. for more than 6 months at a time. If you are a green card holder and you're outside of the U.S. for more than 6 months, they're saying that, you may not be able to get back in, because they might say that you don't want to be a green card holder anymore. Okay, so you have to come back before 6 months. Who knows? Now people are saying don't travel if you're a green card holder. Okay, or petition for his parents. Plaintiff B is harmed because of this delay, and they're asking the court to compel the defendants to take appropriate action to adjudicate the plaintiff's I-485 without delay, and grant such other relief as the court deems proper. Okay, thank you very much for listening. If you like this, give me a comment, give me a thumbs up, a like. Thank you very much. And also, don't forget to subscribe. Thank you very much. Bye-bye.